The resonant thud of the wooden gavel against the polished bench cleaved the profound silence of the Supreme Court chamber. Justice Amy Coney Barrett, her gaze a glacial steel, fixed her attention upon the woman standing resolute before the 9 justices. "Miss Leavitt," her voice, sharp and precise, cut through the hushed tension like a honed blade, "your pronouncements have transgressed the bounds of permissible discourse. This court issues a stark warning. You teeter precariously on the precipice of contempt." Karoline Leavitt, the White House press secretary, a figure of youthful determination at barely 27 years of age, based on referenced information, stood as the youngest individual ever to confront potential contempt charges levied by the nation's ultimate judicial authority. Under the solemn glare of the chamber lights, she remained steadfast at the lectern, her gaze meeting the collective scrutiny of the 9 justices, each holding a portion of her professional destiny within their grasp. Justice Barrett's voice, though modulated and seemingly calm, resonated with an unyielding severity that brooked no argument. "You are hereby granted a period of 7 days within which to formally retract your contentious statements and issue a comprehensive apology to this court. Failure to comply with this directive will leave this body with no recourse other than to refer this grave matter to the appropriate criminal prosecution authorities." A unified gasp, a collective intake of breath swept through the assembled gallery, the sound momentarily disrupting the otherwise oppressive silence. The pens and keyboards of the attending reporters became instruments of frantic documentation, their hurried strokes attempting to capture every nuance of the unfolding drama. Yet, in the face of such formidable judicial power, Karoline Leavitt betrayed no flicker of fear or trepidation. With a deliberate and composed gesture, she unclasped the leather portfolio resting before her on the lectern. "Justice Barrett," her voice, clear and steady, resonated with an unexpected strength that belied her youthful appearance. "I have prepared a comprehensive legal analysis comprising 15 meticulously crafted pages, which elucidates precisely why my statements are not merely protected under the aegis of the First Amendment to our Constitution, but are, in fact, entirely and demonstrably sound in their legal basis." The ensuing moments would etch themselves into the annals of legal history, a dramatic confrontation that would leave the esteemed justices, the assembled media, and the entire nation in a state of stunned disbelief. Justice Amy Coney Barrett, a jurist appointed to the Supreme Court in the year 2020, had swiftly and decisively established herself as a commanding and influential presence within the highest echelons of the American judiciary. Her incisive legal reasoning, coupled with an unwavering and resolute demeanor, garnered a profound respect that transcended partisan affiliations, commanding the attention of both her ideological allies and her legal adversaries. At the relatively young age of 52, she had ascended to become a pivotal and authoritative voice within the court's conservative wing. Her distinguished background as a constitutional law scholar and her prior tenure as a respected law professor at the prestigious University of Notre Dame imbued her with a deep reverence for the sanctity of the judiciary and a keen sensitivity to any public criticism that she perceived as being rooted in ignorance or deliberately intended to mislead. Karoline Leavitt, in stark contrast, embodied a new and assertive generation emerging within the complex landscape of Washington politics. Her appointment as the White House press secretary, a mere 6 months prior, had marked her as a rising star, quickly gaining recognition for her forthright and unambiguous communication style and her unwavering, often fierce, defense of the incumbent administration's policies and pronouncements. However, what remained largely unknown to the wider public was the sharp legal acumen that lay beneath her polished and articulate exterior. A keen intellect honed through diligently pursued legal studies undertaken concurrently with her demanding career within the upper echelons of government service. Before her ascent to the prominent role within the White House, Leavitt had distinguished herself academically, graduating with honors from the esteemed St. Anselm College, earning dual bachelor's degrees in the intertwined fields of politics and communications. This academic success was followed by a less publicized but equally rigorous pursuit of legal knowledge, studies she meticulously completed through evening programs and independent study while concurrently navigating the demanding schedules and responsibilities of her prior governmental roles. The spark that ignited this unprecedented confrontation had been struck 3 weeks prior, with the Supreme Court's issuance of a deeply divisive 5-4 ruling in the case of Fairfield versus Department of Education. This landmark decision significantly curtailed the federal government's oversight authority concerning the educational policies enacted by individual states. In the immediate aftermath of this contentious ruling, during a highly anticipated White House press briefing, Leavitt had delivered a statement that was anything but conciliatory, her words resonating with a force that few had anticipated. "This ruling," she had declared with unwavering conviction, "represents a fundamental and egregious misreading of established legal precedent and the clear intent of the legislative branch. The majority opinion, in its pronouncements, has inexplicably disregarded no less than 7 decades of meticulously established jurisprudence, choosing instead to substitute the subjective preferences of the judiciary for the foundational principles enshrined within our Constitution." These forceful pronouncements, far exceeding the typically measured and diplomatic responses emanating from the White House following Supreme Court decisions, had ignited a firestorm of controversy, sending shock waves throughout the legal and political landscapes. Legal analysts across the nation engaged in fervent and often acrimonious debate, dissecting Leavitt's forceful pronouncements with meticulous scrutiny. The central question that dominated these discussions was whether her statements had indeed crossed the delicate and often blurred line separating legitimate criticism of judicial reasoning from the legally perilous territory of contempt of court. Conservative media outlets, fueled by outrage, vociferously demanded swift and severe consequences for what they perceived as an egregious affront to the authority of the judiciary. Conversely, progressive voices rallied to Leavitt's defense, passionately citing the fundamental principles of the First Amendment and the inherent right of individuals, including government officials, to engage in robust and even critical analysis of judicial decisions. The stakes involved in this unprecedented legal standoff were nothing short of monumental. A finding of contempt against Leavitt carried the very real threat of imprisonment, potentially bringing an abrupt and ignominious end to a career that had shown such extraordinary promise. For the Supreme Court itself, and particularly for Justice Barrett, this direct confrontation represented a critical and highly visible test of the judiciary's authority and its capacity to command respect in an increasingly polarized era characterized by a perceived erosion of deference towards established institutions. For the White House and the incumbent administration, the situation evolved into a high-stakes gamble, raising the fundamental question of the extent to which the executive branch could forcefully articulate its opposition to judicial rulings without incurring significant and potentially debilitating legal repercussions. The unprecedented summons for Leavitt to appear personally before the full complement of 9 Supreme Court justices sent shockwaves across the nation, transforming a legal dispute into a captivating public spectacle. Constitutional scholars, steeped in the history and intricacies of American law, struggled to unearth any truly analogous historical precedents that mirrored the unique circumstances of this extraordinary confrontation. The venerable New York Times, in its editorial pages, declared the situation a constitutional crisis unlike any seen in modern times, a direct challenge to the delicate balance of power. The influential Wall Street Journal, in its analysis, framed the standoff as a head-on collision between the inherent authority of the judiciary and the executive branch's fundamental right to communicate its views and perspectives. As Leavitt stood before the imposing bench in the hallowed chamber that morning, the weight of history, the gravity of the moment, was almost physically palpable, a tangible presence in the charged atmosphere. Her legal team, comprised of seasoned attorneys, had collectively urged her to adopt a posture of contrition, to offer an immediate and unequivocal apology, and to retract her controversial statements without reservation. The White House counsel, anticipating the potential for legal peril, had meticulously drafted a statement of remorse and conciliation for her to deliver to the court. Even the president himself, acutely aware of the potential political ramifications, had suggested a more diplomatic and conciliatory approach, emphasizing the need for de-escalation. However, Leavitt, fueled by a deep conviction in the righteousness of her position, and armed with the fruits of 3 consecutive sleepless nights spent immersed in the intricate details of Supreme Court precedents, cases concerning contempt of court, the established limitations of free speech, and the delicate historical equilibrium between the 3 co-equal branches of the federal government, had arrived at a fundamentally different conclusion. The legal landscape she had painstakingly surveyed had convinced her that a divergent path, a bold and potentially career-defining strategy, was not only justified, but absolutely necessary. This path, however, was fraught with peril, a high-stakes gamble that could either unequivocally vindicate her position and establish a landmark precedent for executive branch communication, or conversely, shatter her professional reputation and bring her burgeoning career to an abrupt and ignominious end. Now, as Justice Barrett, her voice resonating with the full weight of judicial authority, delivered the 7-day ultimatum, the confrontation reached its critical and defining juncture. The moments that followed would irrevocably determine the trajectory of Leavitt's career and potentially reshape the contours of executive-judicial relations. Would she, as nearly everyone anticipated, succumb to the overwhelming pressure, retract her statements, and offer the required apology? Or would she, against all conventional wisdom, dare to challenge a sitting Supreme Court justice on the very interpretation of the law, a move that most seasoned observers considered to be tantamount to professional suicide? A subtle but unmistakable flicker of surprise, a momentary lapse in her otherwise composed demeanor, crossed Justice Barrett's face as Leavitt, instead of offering the anticipated apology, deliberately opened her portfolio, revealing the meticulously prepared legal documents within. A silent exchange, a wordless communication of surprise and intrigue passed between several of the justices, their expressions betraying a keen interest in the unexpected turn of events. Chief Justice Roberts, the presiding officer of the court, leaned forward in his chair, his interest visibly piqued, his gaze fixed intently upon Leavitt. "Miss Leavitt," Justice Barrett's voice, though still measured, now carried a distinct edge of challenge. "This proceeding is not intended as a forum for legal debate. The court has articulated its position regarding your statements with absolute clarity." "I understand, Justice Barrett," Leavitt replied, her composure unwavering, her voice resonating with a quiet confidence that belied the gravity of the situation. "However, before the court proceeds with its intended course of action, I believe it is my fundamental responsibility to address the legal underpinnings of any potential finding of contempt." Justice Barrett's eyes narrowed, her gaze fixed upon Leavitt, a hint of challenge mingling with a grudging respect for the young press secretary's audacity. "Proceed, then," she stated, her voice laced with a subtle warning. "But understand that the substance of your response may significantly factor into the court's ultimate determination." The warning was clear. The stakes were high, but Leavitt remained unfazed, her attention focused on the meticulously organized legal analysis before her. "Thank you, Your Honor. I would like to begin by addressing the specific legal standard for contempt of court as it was established in the landmark case of Bridges versus California. The mere mention of this pivotal 1941 Supreme Court decision, a cornerstone of First Amendment jurisprudence, immediately captured the undivided attention of Justice Sotomayor, who leaned forward in her chair, her expression betraying a keen interest in Leavitt's line of argument. "In Bridges," Leavitt continued, her voice gaining in strength and conviction, "this court explicitly held that criticism of judicial decisions, even harsh and potentially inflammatory criticism, is unequivocally protected under the First Amendment unless such criticism poses a clear and present danger to the actual administration of justice. My statements, while admittedly direct and forceful, did not and do not pose any such imminent threat." Justice Alito, known for his sharp legal mind and incisive questioning, interjected, his voice laced with a hint of skepticism. "Miss Leavitt, you stated, and I quote, that this court ignored 70 years of precedent. That statement, in my view, transcends mere criticism and directly impugns the integrity of this court." Leavitt turned to face Justice Alito directly, her gaze unwavering. "Justice Alito, in the seminal case of New York Times versus Sullivan, this court established the fundamental principle that debate on matters of public concern should be uninhibited, robust, and wide open, and may include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. The court, in its wisdom, specifically included judges and the judiciary within this protected framework." The chamber remained hushed, the silence punctuated only by the soft rustling of papers, as Leavitt methodically dismantled the potential grounds for contempt, citing precedent after precedent, each case carefully selected to bolster her argument. Furthermore, in Craig v. Harney, this court explicitly held that judges are supposed to be men of fortitude, able to thrive in a hardy climate. The opinion in that case explicitly protected criticism of judicial decisions, noting that what transpires in the courtroom is public property. Justice Barrett's expression remained stern, her gaze unwavering, but her attention was now fully engaged, her initial skepticism giving way to a grudging respect for Leavitt's command of legal precedent. "Miss Leavitt," she stated, her voice laced with a hint of caution, "those cases primarily address the rights of private citizens and the press. As a government official speaking in an official capacity, your situation may be distinguishable." It was the opening Leavitt had anticipated, the precise point she had meticulously prepared for. She turned to page 8 of her meticulously organized legal analysis. "Justice Barrett, I respectfully direct the court's attention to the case of Garrison versus Louisiana, where this court specifically addressed the issue of critical speech by government officials. In that case, a district attorney's critical comments about judges were explicitly held to be protected speech under the First Amendment. The court, in its wisdom, stated that speech concerning public affairs is more than self-expression. It is the essence of self-government. The tension in the chamber thickened, the atmosphere charged with anticipation, as observers realized that this was not merely a display of defiance, but a meticulously constructed and powerfully articulated legal argument. Reporters, their fingers momentarily still on their keyboards, watched with rapt attention, their initial assumptions about the proceedings completely overturned. Justice Kagan, known for her incisive intellect and probing questions, leaned towards her microphone, her expression thoughtful. "Miss Leavitt, while your knowledge of precedent is duly noted, there is a fundamental difference between criticizing a judicial decision and suggesting that the court deliberately misinterpreted the law. The latter, in my view, implies bad faith." Leavitt nodded respectfully, acknowledging the validity of Justice Kagan's point. "Justice Kagan, I appreciate that distinction. However, in the case of Wood versus Georgia, this court explicitly protected a sheriff's statements that directly accused judges of bias and political motivation, statements far more pointed and accusatory than my own. The court held that the role that elected officials play in our society makes it all the more imperative that they be allowed freely to express themselves on matters of current public importance. Justice Barrett's initial stern disapproval softened, replaced by a reluctant but undeniable engagement with the substance of Leavitt's legal reasoning. "Miss Leavitt, you have cited several cases," Justice Barrett conceded, "but none of them specifically addresses statements made by White House officials about Supreme Court decisions." "That is correct, Justice Barrett," Leavitt acknowledged, her voice calm and measured. "But I would argue that the absence of specific precedent restricting such speech should favor protection rather than limitation. As this court noted in the landmark case of Texas versus Johnson, we have a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open." The dynamic in the chamber had undergone a complete and unexpected transformation. What had begun as a disciplinary proceeding, a reprimand intended to assert judicial authority, had morphed into a substantive and intellectually stimulating legal discussion, with Leavitt citing relevant cases and articulating complex legal principles with remarkable precision and clarity. Even Justice Thomas, known for his reticence and infrequent interventions, broke his silence, his voice resonating with the gravity of the situation. "Miss Leavitt, while your legal analysis is undoubtedly thorough, there remains the fundamental question of respect for institutions. Your statements, however well-intentioned, could potentially undermine public confidence in the judiciary." Leavitt turned to address Justice Thomas directly, her gaze unwavering. "Justice Thomas, I deeply respect your concern. However, in the case of Landmark Communications versus Virginia, this court specifically addressed this very issue, stating that injury to official reputation is an insufficient reason for repressing speech that would otherwise be free. The opinion further noted that the law gives no protection to the judge who would hide behind the cloak of office to escape public criticism. The directness of the quote, its pointed relevance to the situation at hand, hung in the air, causing a visible shift in the expressions of several justices. The confrontation had escalated beyond anyone's expectations. Instead of a penitent press secretary, contrite and apologetic, Leavitt had transformed the proceeding into a sophisticated and intellectually rigorous constitutional debate, demonstrating a command of legal precedent and a mastery of constitutional law that had clearly surprised and impressed the justices. And she showed no signs of yielding, no indication of backing down from her carefully constructed legal position. Justice Barrett, visibly reassessing her initial approach, her expression now a mixture of concern and intellectual curiosity, leaned forward in her chair. "Miss Leavitt, are you suggesting that there are absolutely no limits to how administration officials can characterize decisions handed down by this court?" "Not at all, Justice Barrett," Leavitt replied, her voice firm but respectful. "I fully recognize and acknowledge that limits exist. Direct incitement to disregard or disobey court orders would clearly cross the line established in Bridges, posing a clear and present danger to the administration of justice. However, criticism of legal reasoning, even strong and forceful criticism, falls squarely within the realm of protected speech under this court's own established precedent." As Leavitt continued her methodical and persuasive legal analysis, the atmosphere in the chamber had undergone a complete and dramatic transformation. The disciplinary proceeding, initially intended as a demonstration of judicial authority, had evolved into an unexpected and compelling masterclass in First Amendment jurisprudence, with the youngest person in the room demonstrating a command of legal precedent and a mastery of constitutional law that had clearly taken the justices by surprise.